It's February 14th. Welcome to yes2hellwith.com. Yesterday you watched a video about Mr. Allen and his concerns about my alleged moral failures concerning hiding money and not providing for my children. This is a continuation and a conclusion of this discussion. A system that does not require proof is not a legal system. A system that replaces authority with narrative is not just. A system that maligns truth to ensure compliance is hostile to freedom. When Mr. Allen says he cannot support someone based upon alleged moral failings, he adopts the same posture used by federal systems when they malign defendants to secure compliance. The discussion shifts from lawful authority to moral condemnation. That is not resistance, that is participation. The Constitution does not protect freedom only for the morally approved. It does not extend a due process only for those who satisfy public opinion. Rights do not depend on commentary. When law is replaced by narrative, liberty retreats. When moral judgment replaces proof, justice collapses. Now let me address Mr. Allen respectfully and directly. Mr. Allen, you are free to withhold your support from anyone. But are you free to treat allegations as settled truth while demanding that others defend themselves against prejudicial narratives that have no bearing on lawful authority? You object to the requirement that individuals study the Liberty Dialogues before engaging in extended debate. That requirement exists to protect disciplined discourse. It ensures that conversations begin from shared structural understanding rather than fragmented assumptions, much like yours. You would not provide unlimited professional time as a paralegal without compensation, would you? I protect my time and framework the same way. The principle is identical. You state that you cannot support someone who allegedly failed to pay child support. That is your moral boundary. But if you accept allegations as conclusions without first examining authority, jurisdiction, procedural posture, and statutory applicability, then you have already abandoned critical structural analysis in favor of narrative. I'm curious if Mr. Allen were told by a judge to defend a man accused of failing to sign a city filing, if Allen would refuse because the defendant did not pass his character test. If he allegedly hid money while he failed to feed his dog. I can imagine Mr. Allen declaring, "No, Judge, I cannot defend a man who is innocent in this case because I deem him to be morally bankrupt in other areas of his life." I don't think that judge would have much use for Mr. Allen in court at all. Now let me address another topic. Yes, I went to prison. It is a reality and not the product of cowardice, I would say. It was the result of a corrupt judicial posture that preferred narrative like Mr. Allen's over jurisdictional proof. I did not concede and accept a plea of guilt to what I believe to be unlawful overreach simply to preserve my comfortable life with my children. Rather, I stood on principle and I paid the cost. I did not endure that experience for vanity or spectacle. I endured it because I believed and still believe that the structural issues at stake affect every American, to include Mr. Allen. Authority, jurisdiction, status, standing, and obligation are not academic abstractions. They are restraints on power. When those restraints fail, everyone is vulnerable. Today, I educate those who seek disciplined understanding. If Mr. Allen knew of my financial condition, and if he understood that the books belonged to the publisher, he might reflect differently and retract his profit motive against me. The Liberty Dialogues are not a profit center. They are a structured body of work for serious study. Thankfully, when my students learn and apply the Liberty Dialogues with AI, they will not need the services of those like Mr. Allen. As for Mr. Allen's professional posture, I would say this without hostility and with clarity. I would not seek his counsel. His reasoning mirrors too closely the posture of modern judiciary tactics, narrative accepted as probative, suspicion treated as leverage, structural inquiry subordinated to personal judgment. We can see where the mentality has taken this country. If we replicate that posture in private discourse, we become indistinguishable from the systems we criticize. Now, my children, I will tell you, did not suffer for anything. Curiously, by the world's standards, I did not allow them to have cell phones, Xbox, or media distractions. We had no television. We read books, told stories, played, wrestled, played kickball, soccer, hide and seek, flashlight tag. I invested my life, my time into my children. Now consider this, Mr. Allen. Did my children suffer because a system weaponized narrative to discredit and secure outcomes? Did they lose a father for 4 years unjustly? Ask yourself honestly, who deprived them? The man who challenged structural authority, or the system that insisted on narrative, creative storytelling? If Mr. Allen understood how and why child support entered the courtroom narrative and the procedural posture under which it was inserted, he would not treat it casually. He would recognize it as tactical prejudice, and he would be ashamed personally and professionally for equating prejudicial insertion with moral failure. I remain committed to truth, to structural analysis, and to disciplined discourse. Freedom does not survive because men agree. It survives because law restrains power, and because some are willing to stand when restraint fails. That is what I did, and that is what I continue to do. Let us seek what is just. Let us demand proof where authority is claimed, and let us refuse to become participants in the very narratives we claim to oppose. And my friends, as always, may truth reign supreme.